Good afternoon. My name is Tim Chance. I am the Tangled Title Attorney at Maryland Volunteer Lawyer Service, or MVLS. Before we start, I just want to please remind everyone to register and join the other Money Power Day booths if you haven't already. So just briefly, wanted to talk about MVLS, who we are and what we do. So MVLS is a nonprofit organization that seeks to connect low-income Marylanders with volunteer attorneys. So MVLS operates in 6 main areas of law. So we deal with family law issues such as divorce and custody, adoption, name changes, and birth certificate corrections. We also deal with consumer issues such as bankruptcy, collections. We also deal with housing issues such as landlord-tenant disputes, foreclosures, deed changes. We deal with tax issues such as income tax disputes. And we deal with criminal record expungements, guardianships, and then the last main area we help with is advanced planning or estate planning. So if you need legal help with any of these issues, you can contact MVLS at the website below, mvlslaw.org, or you can call our intake line at the number below, 410-547-6537, Monday through Thursday, 9 a.m. to 12 p.m. That's what our website looks like. Just go to mvlslaw.org, click on the top banner that says Get Legal Help, and then select Get a Lawyer. These are just our income eligibility guidelines. So, like I said, MVLS helps with estate planning as part of its approach to helping low-income Marylanders face barriers to justice in Maryland. So, I want to talk about estate planning. That's mainly what I do. So, as a Tangled Title Attorney, I assist Marylanders with estate planning issues, estate administration issues, and deed transfers. So as part of my position, I have seen down the line what can happen if proper estate planning is not done. That's why I think it's very important to talk today about doing estate planning beforehand so that you can avoid issues down the line. I just want to talk about the value of estate planning. I want to talk about the pitfalls that can be avoided through estate planning. I want to take the steps, and I want to talk about the steps that you can take to protect yourselves, your families, and then ultimately your legacies. So, what should we plan for in estate planning? Actually, let me circle back. So I just want to give a brief definition of estate planning. So estate planning is the preparation of documents that will protect your health, yourself, and your material assets. So these documents give you the power to say what will happen to your assets, your property, and then with your healthcare. So why should we do estate planning? So it allows us to decide for ourselves what will happen to us when we're sick or dying. And that can be done through the advanced directive and or the living will. We also want to protect our property and assets when we cannot make decisions. That can be done through the financial power of attorney. And as I mentioned before, we want to protect our families and protect our family belongings. And this can be done through the will. So estate planning matters because it's crucial for everyone. Unfortunately, there's a myth that you don't need to do estate planning if you're not wealthy or if you don't have a lot of assets. But everyone has the right to make determinations about how their healthcare can be handled, how their bills will be paid, and to decide who should receive their personal belongings. And these rights apply regardless of your level of income or your assets. Another important benefit to estate planning is it promotes peace of mind and family unity. So having a plan in place is a kindness to our families in troubling times when making decisions could be particularly difficult. It allows us to have these plans beforehand. So there is a set plan to point to during a crisis. Additionally, like I said, for family unity, it also allows us to keep our assets in the family. So this is anything of value, whether that's monetary value or sentimental value. It could be the family home or the family Bible. This helps to stabilize our communities and to build intergenerational wealth. So the first document I want to talk about today is the Advanced Directive. So this document can become effective immediately or upon incapacity. So incapacity is when a doctor determines that you can't make decisions, such as if you fall into a state of unconsciousness. So there's two parts to the advance directive. The first is the part that allows you to appoint a healthcare agent. So that's someone who can handle your healthcare decisions and communicate your wishes if you're unable to communicate. This is not just end of care. This can be temporary, like a surgery or an accident. The second part of the advance directive is the living will. That is optional. And this lays out your medical preferences and end of life situations that will guide doctors to decide how to best treat you if you're unable to communicate. So some things to think about when you're looking to draft an advance directive. So the importance of the advance directive is it allows you to name a healthcare agent that presents just one singular voice to speak with the doctor and give a decision. So you have the opportunity and the right to pick a person who understands your values. Let's say you're in favor of pain management drugs, even though they can shorten your lifespan. You can communicate that wish to your healthcare agent so they can then direct your physician and the medical staff to then honor that wish. So if you have a healthcare agent, it allows the doctors to receive a quick, decisive answer because of that one unified voice. It also takes the burden off of family members from deciding who will speak for you if you have named someone in advance. If you don't have an advance directive, if you don't have someone named as your agent, you can have many eligible family members who could legally make decisions for you. So there could be a variety of voices, I guess, coming together to create some type of, there's no unity. It's the best way to put that. So the second part of the advance directive is the living will. So the living will aspect of the advance directive is where you write out your personal preferences for your care and end of life situations. I can help your family and your appointed healthcare agent to make decisions on your behalf. I do want to clarify though, this is not a medical order. So that's the most, the medical orders for life-sustaining treatment, and the most contains directions about CPR and other life-sustaining treatments. And that document must be signed and dated by a licensed Maryland medical provider. So the living will is where you indicate your personal preferences for your end of care situations. Some logistical issues to consider when you're thinking about advance directive is who you're going to name as your healthcare agent. So you obviously want to have a first choice, but you want to have a backup in the event that your ideal agent is unable to serve. Is there anyone you want the healthcare agent to consult with? You want to think about that. You're going to need the contact information for each person, so their full name, their address, and their phone number. For the living will, you're going to think about what level of care do you want? Do you want all, some, or no medical interventions? You also want to think about organ donation, final arrangement preferences, and what's going to happen to your body after your passing. So how can you execute an advance directive? So the advance directive can be executed three ways. It can be done in writing, orally, or electronically. So if it's done in writing, it must be dated and signed by you. There must be two witnesses. The witnesses can be any competent person, but the healthcare agent cannot serve as a witness, and at least one witness must not be entitled to any of your estate. So at least one witness may not receive any type of benefit upon your passing. And there's a standard form accessible at the Attorney General's website. The link is included right here, but I can also make it available for today's attendees. The advance directive can also be executed orally. So if it's executed orally, it must be done in the presence of the attending physician and at least one witness. It must be documented in your medical record and dated and signed by the physician and the witness. And lastly, advance directives can be executed electronically. So Maryland recognizes electronic advance directives that are generated in services and meet the standards set by the Maryland Healthcare Commission. So once you've executed your advance directive, and once it's signed, you want to make copies to give to your primary care physician, and if you feel comfortable, to your healthcare agent. Okay, so the next document I want to talk about is the financial power of attorney. So just like the advance directive, this document is effective during your lifetime. This document appoints an agent to make decisions about what will happen to your property, your assets, and insurance while you're still living. So this document will go into effect right when you make it, unless you specify otherwise. So if you specify otherwise, that's known as a spring-in power of attorney. So an example of that is it only comes into effect after a certain event, such as when you become disabled. So it's very important to be careful about power of attorneys because they go into effect immediately unless you specify otherwise. So because of that, there is the potential for abuse if it goes into effect immediately. So let's put a lot of thought into that, whether you want it to go into effect immediately or if you want it to be a spring-in power of attorney. And this document lasts until death or until you decide to change it. So with the financial power of attorney, the agent can arrange the payment of everyday expenses such as rent, doctor's bills, any other bills such as insurance. They can collect government benefits, handle bank transactions, file and pay your taxes, manage your retirement accounts, and more. They will deal with insurance on your behalf to get your full benefits for you. The financial power of attorney is a simple way to arrange for someone to manage your finances if you become incapacitated. So I want to touch back on that initial myth about only needing estate plan documents if you're wealthy. So even if you're not wealthy, are there reasons for a financial power of attorney? So yes, like I just touched upon, they can deal with insurance on your behalf to get your full benefits. Like I said, they can manage your bills. So even if you don't have large sums of money, there are still everyday expenses and everyday tasks that can be handled by your agent with the financial power of attorney. So if you don't appoint someone yourself through a financial power of attorney, the court may appoint someone if you're incapacitated. And this can end up being a complicated and time-consuming process. So there's two types of financial powers of attorney. The first is the general power of attorney. And the general power of attorney gives the agent the power to act for you in all business and personal matters. The limited power of attorney grants only the powers specifically defined in the documents. So in the limited power of attorney, you can dictate specifically what powers they have. So if you want to dictate specifically that the agent can only manage a certain bank account, you would outline that in your limited power of attorney. So how do you execute a power of attorney? So in order to create a power of attorney, first, you must be at least 18 years old. You must intend to give the power to the person designated in the document. So you must intend to give this power to the agent, and you must be mentally competent. The power of attorney must be in writing, it must be signed, it must be notarized, and it must be signed by 2 or more adult witnesses who sign the power of attorney in the presence of you, so the principal, and each other. And just as with the advanced directive, there's a standard form. This is also available through the Attorney General's website. Both a general power of attorney form is accessible at the website and a limited power of attorney form. I can also make these available to today's attendees as well, but the link is also there. So just as there are things to consider with the advanced directive, there's some things you want to consider with the financial power of attorney. So who should you name as your agent and your financial power of attorney? It's really important to name someone that you trust. As I touched upon earlier, there is the potential for abuse. So you want to only give this power to someone that you trust to act in your best interest and to act in good faith. Do you want to name one agent or do you want to have joint agents in the power of attorney? That's something to consider. Who would you want to name as your backup agent in the event that your preferred agent is unable to serve? And lastly, just as with the advanced directive, you'll need the contact information. So that's the full name, address, and phone number of the agent and the backup agent. And the final document I want to talk about today is the last will and testament. So the will, unlike the first two documents, unlike the power of attorney and the advanced medical directive, it only becomes effective after your passing, after your death. So the will names someone to handle your estate. This is known as a personal representative. It can also name the guardians of any minor children, and it will say where and to whom your assets will go, and it can authorize the payment of funeral expenses. Where it says where and to whom your assets will go, it also speaks as to how the assets will be divided, whether it's equally or which percentage, or however you intend, you would specify in the will. You can also take care of special requests, such as I touched upon the family Bible earlier. You can specifically bequest the family Bible to an intended heir. So with the will, there's no standard form for this. So it's a very good idea to speak to an attorney and to get help from an attorney to draft your will. I know MBLS assists with wills. I know there are other organizations in the state that can assist with drafting your will. So I strongly advise speaking to an attorney for the will and for the other documents as well. You can have an attorney assist with other documents, but with the will specifically, there's no pre-existing form. So in order to create a will, though, you must be at least 18 years old. And at the time of making the will, you must have the mental capacity to make a valid will. So you must understand what the will is intended to do. You must understand the relationship between you and your intended heirs. And you must understand which assets you have and where they will be going. It's the form of the will. It must be in writing. It must be signed. And when it's signed, it's going to be signed by it's going to be signed by you, but also signed by 2 or more adult witnesses who sign it in the presence of you and each other. So as with other 2 documents, there's always things to consider. So you want to think about who's going to be your personal representative. So this person is going to oversee the distribution of your assets. So I think a recurring theme with these documents is you want to name someone you trust. So this person is going to be in charge of ensuring that your wishes are enforced. So you want to have someone that you trust to do that. If you have children, you're going to want to think about who you're going to name as the guardian, and you want to think about a backup guardian. And you also want to think about your assets and how those assets are going to be distributed. So like I said, it can all go to one person. It can be equally divided, however you wish, but you want to put some thought into that and any special requests. So if there's any items with special sentimental value to you, such as the family Bible or like a stamp collection, you want to think about where that's going to go. You want to make sure once you have the will drafted that you store it somewhere safe, such as a safe. But also in every county in Maryland, you can store it at the Register of Wills for $5. So you're not required to take it there to file, but it is strongly encouraged. So it's good to have the original will there because only the original will counts after your passing. So I said I wanted to touch upon some pitfalls that can occur if you don't do proper estate planning. So what happens if you die without a will? So if you die without a will, your property is going to be distributed by intestate succession. That is by the laws of Maryland. So generally that means that your spouse, then your children, and then your other surviving family members will inherit your assets. And that could go against your wishes. So that's why it's so important to have this plan in place. Also, the order of priority for the personal representative may not be what you want. It may be someone that, like I said, you don't have that innate sense of trust for, someone that you can't trust to actually carry out your wishes. For minor children, they can be placed in the custody of whoever seeks guardianship, or the court will decide that. So when these things happen, when you pass without a will, it creates the opportunity for conflict. So we talked earlier about family unity. So if there is an intestate estate, that increases the opportunity for friction and fracture in the family, which goes against the hope of bringing the family together. So actually, I just want to touch on a few things. So I talked briefly about intestate succession. So like I said, that's the general hierarchy of spouse, then children, then other surviving family members. But so if you have a non-traditional family though, like a partner or an unofficially adopted child, they can end up overlooked. So that's something to strongly consider it as why a will is so important. So those are the 3 main documents. There's the will, the advance directive, and then the power of attorney. There's other planning options to consider outside of these 3 main documents. So one is you can name a beneficiary designation on your life insurance, retirement funds, and that allows those funds to pass directly to your intended heir or beneficiary without going through probate. In order to do that, though, you have to speak to each agency individually. Similarly, if you have a bank account, you could have a payable on death designation. So bank accounts, stocks, bonds, and even cars can be transferred on death after your passing, and you have to go through each individual agency for that as well. Then for the major asset in many families, the house, is there a way to get that piece of land, that piece of property directly to an intended beneficiary without going through probate? There is. There's the life estate deed. So the life estate deed grants future ownership of your home or your land to someone else. So the benefits of a life estate deed are you can avoid probate that way. You also avoid the risk of joint ownership because you're not naming your son or your daughter as a joint owner. You don't run the risk of the creditors coming after your home. Well, their creditors, so your children's creditors coming after the home in the event that they have creditors. So the property remains safe during the course of your lifetime. And if you're a homeowner, your name is on your deed, it allows you to go after homeowners property tax credits, home repair programs, water credits, utility bill credits. It's programs that make it that much easier to keep the home within your family and to pass it on to future generations. So for the life estate deed, it's very important to talk to an attorney about that. And as it happens, we actually have an upcoming Homeowners Clinic on October 27th. It's going to be remote. It's going to be from 4 to 7 p.m. So during the Homeowners Clinic, if you register, you can register by going to myhomeMyDeed.org. You will meet with an attorney virtually, so over the phone, to go through all of these documents. The first thing they'll look at is whether your name is on the deed to the property that you're living at. If it is on the deed, the attorney will talk with you about how to ensure that the property stays within your family. So that's making sure that you have your estate plan documents in order. That's making sure you have your advance directive, your power of attorney, and your will. But also, can you get a life estate deed? They'll help you draft that as well after the claim. If your name is not on the deed, we talk about how can we get you onto the deed so you can access all those benefits that we touched upon in the last slide, the tax credits. So that requires probate. So if your name is on the deed, then we talk about how we can open an estate and administer the estate to go through transferring the property from the deceased homeowner into your name. And then it circles back to that original estate planning talk. So once you have everything in order, we need to talk about the steps we took to get here, but how can we ensure that this doesn't happen in the future? And that's when we talk about estate planning again. So, like I said, we have an upcoming clinic on October 27th from 4 to 7, and I encourage everyone to check out myhomemydeed.org to learn more about the My Home My Deed My Legacy program and to register for the clinic. And I just wanted to end with this brief video on the importance of ensuring that you protect your home, your deed, and your legacy.
Right now in Baltimore, 3,560 homeowners are at risk of losing their houses to tax sale foreclosure. The number is rising daily. Reach out to Maryland Volunteer Lawyer Service to protect your home, your deed, and your legacy.
So you can also call that number right there, that 443-451-4082 number to register for the clinic.
Right now.
Okay, so that concludes today's workshop. I just want to let you know, if you have any questions, feel free to put them in the chat box. I'll be answering questions throughout the course of the webinar, but I'll also be answering them afterwards. So please put them in the chat box and I'll be very happy to answer them. And thank you all for attending and thank you for having me today. Take care.